Hi, I'm Kelly Balamuth with Balamuth Law, and this is my social media minute on estate planning. Today we're going to talk briefly about steps to take when you have minor children with regard to an estate plan. There are several steps that you definitely want to consider taking. The first is to name permanent guardians for your children. These are people that would raise your children if you're not able to. At Balamuth Law, we have a number of ways to help you make these very challenging decisions, and we're happy to talk you through it. The second important step to take if you have minor children is to name temporary guardians, also known as first responders. These are folks who would step in an emergency. For instance, let's say you and your spouse, if you have one, go out to dinner and a tragic accident happens on the way home and you're unable to get home. If you haven't named first responders, your babysitter or whoever's giving your child care won't really have any choice but to turn your kids over to Child Protective Services. But if we've named temporary guardians or first responders, those people can step in to make what it would otherwise be a very stressful situation for your children a little bit less stressful. Another important step to take for minor children, and not everybody needs to take this step, but you might want to consider excluding potential guardians. At Balamuth Law, we can prepare discrete documents so that if you have somebody in your family that you don't want to raise your kids, we can put that down on paper. And it would only become known should something happen to you and that person that you don't want raising your children steps forward. It acts as a blocker, basically, to make sure that your kids don't end up with somebody that you don't want raising. If you have kids that aren't minors, that are 18, 19, 20 years old, then you definitely want to consider having a medical power of attorney for your adult child. That will allow healthcare providers to speak with you should something happen to them. I personally heard horror stories of a number of moms whose kids have gone off to college, had some sort of accident or something, ended up in the hospital far away from where they were raised, and then the hospital staff is not able to speak to the parents because the parents don't have a medical power of attorney for their adult child. So it's a very easy document to prepare, and everybody who has an 18, 19, 20-year-old or even older should have one for their children. Those are 4 important steps to consider if you have children with your estate plan.